But let me take that opportunity in the last preparations here to welcome you back to session 4. I'm sure your stomachs are full of excellent food, as your minds are full of excellent ideas and comments to share in this next Davos-style gathering. Again, Davos-style is the order of the day. Now we will be looking at international legal cooperation, as well as cross-border civil procedure issues and all the issues that surround those areas of law. We will also consider how private international law and civil procedure do interrelate. After that, we have a 30-minute coffee break, and we're sticking to the time this time, I think probably quite accurately. I hand over to the moderator of this session, Mr. Bill Fritzlen, Supervisory Attorney in the Office of Legal Affairs for Overseas Citizen Services at the U.S. Department of State. Thank you, Bill.
Thank you, Tom. Can folks hear me? Good afternoon, everybody. I'm guessing we all had a very nice lunch. I want to speak, I think, on behalf of all of us, thanking the hosts, the organizers, and the supporters of the conference for providing such a wonderful venue and a wonderful event. And very nice lunch this afternoon, too. Like the session before, I think we're all in a little bit of an unenviable position in that we come between you and coffee. So I am going to try and work with that. I want to just briefly introduce my colleagues on this panel. We have Justice Balken from Kazakhstan, and we have Professors Guo, Professor Zablud, and Professor Fernández Arroyo. I, if you will notice, am the only one here who is not a judge or a professor. So I am going to let them do most of the speaking, although I warn you, I am a lawyer, so I'm perfectly capable of filling up the silences if need be. So in any event, we generally are here to talk about two conventions, the Service and the Evidence Conventions, which are really fundamental to international civil procedure, as it were. But I would be remiss if we didn't take the opportunity to learn from the expertise of Professor Zablud, who is here with us from Australia today, who is one of the world's top experts on the Apostille Convention. And the reason I think this is important is because one of the topics for today is how do these conventions, which they are, I'm dating myself, these conventions that are younger than I am, Apostille is older than I am. Apostille has shown the capacity for a quote-unquote older convention to adapt to modern times and modern technologies without the need for substantive change to it. Whether the same holds true for service and evidence is, of course, dependent upon how we interpret what they require us to do. So we thought it would be helpful if Peter gave a few remarks to open up to sort of talk about the Apostille Convention and give us some context in what we're looking at moving forward with service and evidence and indeed access to justice as well. All of the conventions that sort of fall into the international legal cooperation and civil procedure category. So without further ado, Peter.
Well, with your leave, Bill, how are we going up the back? Can we hear this one? Great. Firstly, can I echo your first remarks and give my compliments to the Hague Conference, and in particular to the Secretary-General, Christophe Bernasconi, our old friend. Thank you very much for the honour and privilege of the invitation to participate in this landmark event. My compliments also, if I may, to the Department of Justice of the Hong Kong Special Administrative Region and to the event sponsors, and very sincere thanks for your wholehearted and generous support of this very important event. And finally, and if I may say most importantly, my compliments also to the distinguished guests, the moderators, the presenters, and to you, the participants, attending this particular conference. I'm not sure, Bill, that I'm entirely comfortable being described as an expert. I've always understood an expert to be a person who knows more and more about less and less until finally he knows everything about nothing. But this afternoon, I'd like to share a few thoughts about one of the best known and one of the most iconic of the Hague Conventions, the Convention of 5 October 1961, abolishing the requirement of legalisation for foreign public documents. It's colloquially known as the Apostille Convention. Now, for those of you, particularly from common law jurisdictions, it ain't the Apostille Convention, it is the Apostille Convention. It's a French word, and we'll come back to that in a minute. The Apostille Convention was first signed on 5 October 1961 and entered into force on the 24th of January 1965. It has been around for half a century. And for more than half a century, it's been a jewel in the Hague Conference crown. It's one of the most successful and highly respected and highly regarded of the Hague Conventions. It is a classic example of international cooperation and of private international law in operation, and it has lasted the test of time. Now, for those of you who don't know, let me ask you, what does this convention do? Well, by the use of an internationally recognised standard form certificate called an apostille, it makes it easier, simpler and faster to authenticate public documents emanating from one contracting state for production and use in another. Data collected since the 1990s indicates that in all probability, some several 100 million apostilles have been affixed to public documents over the past 50 years. A huge number. Now, coming back to the word apostille, it's, as a matter of interest, is a 16th century French word which meant a short recommendation written by an influential person in the margin of a document or at the foot of a letter. When this convention was adopted by the Hague Conference 9th session in October 1961, French was the language of diplomacy. So it really isn't surprising that the certificate instituted by the convention was given a French name, apostille. This convention has been acceded to by 115 contracting states. That's 60% of the world's sovereign nations. It's a greater number than any other Hague Convention. Those 115 contracting states account for approximately 45% of the world's population. The Convention has provided international trade and commerce with a simple, workable and acceptable solution to the burdensome administrative mechanism of legalisation of public documents for use internationally. And for those of you who come from countries that are not party yet to the Apostille Convention, you know how difficult it is to legalise and how time-consuming it is to legalise public documents emanating from your country going to other countries and vice versa. Most importantly, the Apostille Convention has assisted literally millions of people around the world in conducting their cross-border personal and business affairs, and it continues to do so. Now, as is the case with virtually all international conventions, the Apostille Convention has had its challenges, both generally and in relation to its practical operation. Fortunately, none of these challenges is life-threatening. To the contrary, the Apostille Convention is alive and well, and I think it's safe to predict that it still, after 50 years, has a very bright future. Indeed, since the turn of this century, which is really only, 17 and a bit years ago, the Convention has entered into force in 47 large and small countries. So without doubt, the greatest single challenge for this Convention over the short to medium term is to increase the number of contracting states from amongst the world's 78 sovereign nations which still remain outside its ambit, and engaging with and bringing into the fold all, or at least a significant number of those nations, which between them account for 4.1 billion people, approximately 55% of the world's population. It's no easy matter, is it, Christoph? But in that regard, I must say it's encouraging to note that Iran, Malaysia and the Philippines are all looking to become party to the Convention in the near future. I would think Iran's accession will give impetus to its trading partners and other Middle Eastern and Gulf countries that are not yet parties. Give them impetus to come on board. Malaysia and the Philippines, as two of the foundation members of the ASEAN countries, are both very, very influential in their region. Brunei has already led the way amongst the ASEAN states, but once Malaysia and the Philippines join Brunei, hopefully it won't take too long for the remaining ASEAN members to follow suit. All being well, it shouldn't be too long before Canada joins the other states in the Americas which are already states party to this convention. Africa's had a few mentions in the last day or so. Africa, as you know, is the world's second largest and most populous and second most populous continent. Its 54 sovereign states are home to over 1.2 billion people who between them generate an estimated annual GDP to the order of $2.6 trillion US dollars. Regrettably, so far only 13 African states are party to this convention, and it's hoped that within the coming years a significant number of the remaining 41 states will accede. Now, even though the special administrative regions of Hong Kong and Macau are, for historical reasons, both party to the Apostille Convention, regrettably the People's Republic of China itself hasn't committed itself. For obvious reasons, it is important that the PRC, as a major world power and as a significant member itself of the Hague Conference, for obvious reasons, it's important that the PRC sees its way clear sooner rather than later to come on board this convention. The second challenge which the convention faces is a practical one, namely the number of competent authorities that are appointed under the convention. Just to explain, when a country comes on board, the central authority within the country appoints one or more competent authorities as the authority to affix the Apostille Convention. For instance, in Australia's case, the competent authority is in fact the Secretary of the Department of Foreign Affairs and Trade, and the Secretary delegates his or her authority to the various state offices of the department, so that Australia is a relatively small country as far as population is concerned, even though it is a vast country geographically, and it has officers in each state and territory who are given the authority to affix apostilles. For any number of reasons, which I won't go into at the moment, but mostly the number of administrative divisions in a country, the majority of contracting states have chosen for their relative domestic purposes to designate a number of competent authorities to affix apostilles. Now, at the bottom end of the scale, I don't mean this nastily as far as the country is concerned, but numerically, population-wise, at the bottom of the scale is Niue, which has got a population of 1,200 people. It's the smallest contracting state of the lot, yet it has seen fit to appoint 7 competent authorities. They all actually operate out of the same office. At the other end of the scale, we have the United States, which is the world's 3rd most populous country, and the US has understandably designated 170 competent authorities, including the clerks and deputy clerks of the US federal courts and senior officers in each of its 56 individual states and territories. South Africa, we got any South Africans here? South Africa has included 1,914 magistrates amongst its designated authorities. So all in all, around the world, there are several thousand competent authorities designated by the contracting states. And one of the problems in practice with this convention is that we know that a number of these competent authorities have never affixed an apostille to a document in their lives and wouldn't know an apostille if they fell over it. So the problem, practically, is that for existing countries and for those countries coming on board, to ensure that their competent authorities, or at least the staff of the competent authorities, are adequately and properly educated in the convention and in the practicalities of dealing with the affixing of apostilles. In that regard, if I may say, there's some terrific stuff that the Permanent Bureau of the Hague Conference has prepared, and for those of you who are involved with your competent authorities or with your central authorities in your states of origin, don't forget to use those materials because they really are excellent. If I may just briefly, Bill, turn to the question of the capacity of the Convention to deal with electronic public documents. In this digital age, which in many ways, if I may say, is an age of misinformation and disinformation, public and private documents and records are increasingly being generated electronically, particularly public documents such as court decisions, civil status documents, and other government's administrative documents. The ability to store and transmit documents and records electronically has given rise to issues of privacy, security, and authentication, which were completely unknown in the paper environment in which this convention was drafted. But interestingly enough, even though the convention was adopted in a paper world and for the foreseeable future will largely be applied to paper documents, the framework of the convention allows for the authentication of electronic documents and the affixing of electronic apostilles. So happily, the electronic revolution, which all of us are just a shade frightened of, doesn't require this convention to be revamped or replaced. The electronic apostille is one component of the electronic apostille program, the EAPP. The second component of the EAPP is an electronic register. Now, Christoph's just having a quiet little smile there because the truth of the matter is that the EAPP is actually his brainchild, and it was developed some years ago by him and by the Permanent Bureau together with the National Notary Association of the United States. And the electronic apostille is now well and truly part of the fabric of this convention. At the end of March of this year, more than 200 competent authorities in 33 civil law and common law contracting states are operating one or both components of the AAPP, which is clear and tangible demonstration of support for the program and support for the convention as it enters into this electronic age. If I may say, though, that the genuine challenge posed by electronic documents is faced by the competent authorities and not by the convention as such. As noted by Professor Luciana Duranti, who is the director of the International Research Project on Permanent Authentic Records in Electronic Systems, known generally as the Inter Pares Project, as she said, quote, "The ability of reproduction and manipulation makes it difficult to identify the final, official, reliable and accurate version of a digital record. It is therefore critically important to develop the body of theory and methods necessary to ensure that digital records can be created in accurate and reliable form, and that they can be maintained and preserved and accessed in authentic form, both in the long and in the short term, that they can be used by those who created them and by society at large, regardless of technology obsolescence and media fragility." So it is currently entirely a matter for the individual contracting states and for their competent authorities to determine how to authenticate the general nature of electronic public documents published within their jurisdictions. It's for the competent authorities to liaise with government agencies and instrumentalities in particular to come to terms with the fact that the electronic future is now, and that their service delivery must accommodate that reality. But if I may say, in conclusion, Bill, internationally recognised standards and guidelines relating to the integrity, reliability, authenticity and preservation of electronic public and private records and the related issues of privacy and lawful accessibility have to be developed as a matter of urgency. Those standards and guidelines will be based on the results of current research, such as the Inter Pares Project, and they will be fertile ground for future Hague Conventions. Not yet. Thank you very much for your attention. Much appreciated.
Thank you very much, Peter. I think that really helps us to sort of contextualize where we stand now with the Apostille's sister civil procedure and judicial cooperation conventions, primarily the service and evidence conventions, which are facing the same issue. Many jurisdictions that are party to these conventions already have provisions for electronic service of process, electronic proof of service. Also, the concept of testifying either live or by deposition necessarily is at the forefront of these questions when you are dealing with cross-border litigation. To give you an idea, I think Peter's explanation of the Apostille Convention really showed us how the Hague Conference stepped up and recognized a need. Because if before that convention, say, for example, I wanted to use my birth certificate in Hong Kong, I would have to go through an authentication process that was at least 3 steps long and that I would have to pay each time. Whereas now, because I could use my birth certificate under the convention, I would go and I would pay once, and it's done. My office is responsible in the United States for pre-convention international judicial cooperation in the sense that we process the predecessor to the convention, namely the dreaded letters rogatory. Anyone who is familiar with that phrase will know why I say dreaded. It is tempted to say ancient process for sending a request for judicial assistance from one country to another. So, for example, if I in the United States want to sue someone in Hong Kong, pre-convention, I would ask the judge to sign a request for judicial assistance saying, please, court in Hong Kong that has jurisdiction over this person, please help me serve process on them. So what do I do with that? I get that authenticated. I send it to the Department of State, to my office. We send instructions to our Consulate General here in Hong Kong, mail the stuff actually physically to the office here. They provide a diplomatic note. It goes to the Hong Kong authorities, which send it to the Department of Justice, which send it to the appropriate court, which undertakes the action, which then the whole process goes back and forth. And when people ask me, depending on the country, how long this process takes, I say 6 months to never, because there are instances and countries where we never get a response. The evidence and service conventions have replaced this process with one where if I want to serve process on a person in a foreign jurisdiction that's party to the convention, I merely fill out a form and I send it to the central authority in that country. I don't have to go through this whole process. And the central authority will provide service and then return it. It cuts tremendous burden out of the process, also tremendous price. By regulation, my office is required to charge $2,275 US for each instance of letters rogatory, whereas under the service convention, it's usually free. The same for the evidence convention. It makes cross-border litigation much more efficient and much more certain, because the one thing that these conventions do is they take us out of a world where you have to figure out what do I need to do in the absence of any direction. These conventions provide rules of the road. You know what the rules are in the country that you're trying to achieve either service or obtain evidence from, which is a tremendous, tremendous help to litigators. And now we are in the situation where the questions are arising, well, you know, do I have to go through the central authority? Would it be possible? Can't I just call this person up and depose them? Can we do a video deposition via Skype? Can I email the service to this person? And so these are questions that are currently being studied by one of the Hague working groups on electronic matters as they relate to the evidence convention. But we have a path forward that was shown by the Apostille Convention, that it's possible to look at a convention that is in and of itself technology neutral, from paper to electronic, and see where we can get. So that's just sort of the context. I don't want to hog all the time myself, but I'd like to turn it over to two of my, first to the Justice to discuss recent developments in Kazakhstan, which has recently acceded to both conventions, to get an idea of how these problems may be faced in the future and what their experience is, for the most part, in joining this convention. And then we'll go to Professor Guo, and then afterwards to Professor Fernández Arroyo to discuss the next steps in the sort of evolution of the judicial assistance and cooperation conventions. So, please, Mr. Justice.
Good afternoon, ladies and gentlemen, dear friends and colleagues. First of all, I would like to congratulate HCCH with this remarkable event, with this anniversary, and I would like to express my gratitude on the name of my colleagues for such great job that during all of this time Hague Conference performs for legal society, for global world, to harmonize international private relations, to assist us in making life easy in every corner of the world. And also I would like to express gratitude to partners of this Congress, to Department of Justice, Hong Kong University, and other sponsors of this conference. So regarding our session, every session were very exciting. Last one was very interesting, and it's related with cooperation in on civil procedure issues. So before coming to this Congress, I explored again and revised several conventions, Hague Conventions, on civil procedure matters, and I find out that they are very effective. They provide us opportunity to ensure rule of law, effective judicial protection and cooperation, and stability in civil turnover. And I also would like to emphasize benefits of Hague Conventions on civil procedure, on service abroad of judicial and extrajudicial documents, on taking evidence abroad, and international access to justice, that all of these documents are flexible in relation to, regarding to national procedures. These conventions and recommendations, valuable recommendations of commissions of Hague Conference, they encourage us to use new technologies, IT technologies, where they were already mentioned here before. They establish international platform for successful interaction of countries. So Kazakhstan actually is a party to several conventions on civil procedure matters, but situation wasn't maybe successful all the time. In history, my country comes from a post-Soviet region. Since 1991, we get independence, and we faced with great challenges, public and state crisis, economical crisis, and every country, every member of community of independent states faced with challenges to establish own international framework, a national legal system. But what was main difficulties for us? Actually, in past, economy was belonged to state, and just a few maybe subjects, entities could maybe cooperate on international level. But since independence, on this area, on this huge area of Eurasia, we get open market. We decided to develop society on freedom manners, on protecting civil rights, and so on, etc. So, and from that period, I might suppose, it's just my own personal opinion, judges faced with difficulties in implementation of international documents. And I feel that we could have a wrong understanding of international agreements and conventions on legal aid. I can assume that maybe some of my colleagues would, for example, pursue wrong preferences as national interest of state, and so on. But it's in past, and it's a history. Nowadays, governments in CIS countries, in government of Kazakhstan, aim to provide friendly environment for investments, for to market, to human relations. So, and Supreme Court as a judicial policy maker supports fair relations, fair regulation. So. Just before coming here, I contacted with my colleagues from the Court Administration Department under Supreme Court, which is a central body for several conventions. And my colleagues from this office, they maintain database. So nowadays we have a specific, in our internal software for e-cases, we have a specific database where we keep records on every incoming and outgoing requests. We can see what happens in region, what is the results for results for the case or results for the request. At the same time, couple years ago, Supreme Court of Kazakhstan established also international council with international experts to assist in developing and promoting judicial reforms, legal reforms. So in 1916, I participated in drafting several recommendations for this council, and we enacted these recommendations. So I would like to just maybe share with you what experts and members of this council advise us. So we were recommended to monitor court practice, keep in centralized manner all records and information on every case for legal assistance, recognition or enforcement or any other requests. Our International Council also recommended to amend Civil Procedural Code by rules to allow appeal against every refuse on legal assistance by national courts. And experts also advised us maybe to explore and maybe to follow to the experience of Supreme People Court of China, where there is a circular for dealing with such kind of appeals against refusing to requests. We got a recommendation to use IT technologies as a blockchain. Today we had a wonderful presentation to make procedures easy and fast. And this recommendation corresponds to Hague Convention of 1965 on service abroad of the judicial and extrajudicial documents in civil and commercial matters. We were recommended to strengthen the professional capacity of judges and court officials in this area through trainings and courses. And I also would like to emphasize the value of recommendations by HCCH Commission on conventions and all other additional resources as case law, publications. And by the way, I recognize that web resource of HCCH is very logical, very convenient to use. We can find many resources there. What else? We got recommendations to avoid refuse in providing legal aid in case of minor mistakes, confusions in applications and requests, providing some kind of assistance how to improve these requests and applications. And finally, International Council under Supreme Court recommended to national courts that national courts should take the first steps in the principles of mutuality in absence of agreements. So that was idea that, for example, when national courts and judges in our national system, they faced with absence of any agreement or convention, for example, in a very serious matter like in recognition and enforcement, then there is a principle of mutuality. But how to find, if, for example, there is no case with a certain country, what to do? So there is a recommendation and advice, and I agree with this position that maybe to the country and to jurisdiction which targets some kind of open market, some kind of reliable, how to say it in English, reputation. Yeah. It's better to make first step in this way. So I agree with this recommendation, and I believe that it's very helpful. And regarding performance, regarding practice on Hague Conventions on civil procedure, I am happy to say that in our jurisdiction, actually, we don't have any problem with enforcement with performance of these conventions. Our courts follows to rules of this convention, but from another hand, I heard from my colleagues that some certain outgoing requests they took a long time for dealing with in foreign countries. Of course, maybe it's like issue of national systems. Civil procedures might be different in different countries with different terms, but anyway, it's one of the challenges for us how to make procedures easy and fast. And today we also discussed a little bit the prospects for a new convention on enforcement of foreign judgment. So we expect this document very much. So I think that there are a lot of things to do in future. Yeah. So thank you very much. Yeah.
Thank you, Justice Balken. And we will turn it over to Professor Guo.
Thanks. It's an honor and great pleasure for me to take part in this conference. One of the proposals, I think I want to express my congratulations because of our School of Wuhan University. Congratulations, the 125 Universal Celebration. And second, I need to say thanks. Thanks the help and the support from the HCCH to our school, Law School of Wuhan University. Thanks for accepting our students to train them. The close cooperation have bring benefits to our university. Wuhan University is a very famous university in China, and the Law School of Wuhan University is also top 5 in mainland. So I hope we have more cooperation between us. In fact, the civil procedure law and international is not my research field. I'm a real outsider. But I think talk about a very simple question, just less than 5 minutes. I want to talk about shadow bank, how to bring shadow bank to light. Another side is how to remove shadow bank out of the shadow. Key words: necessary, difficulty, and approach. As we have known, the number of non-bank assets has risen, not only in the advanced countries, but also in developing countries, including China. The number of shadow bank assets is estimated about 8 trillion, following the US and the UK, that are the third in the world. Because the cross-border, it can transfer risk from one country to another. So the international organization, including FSB and IMF, also strongly recognized to regulation should be put on the shadow banking system. But the effects are less effective and less meaningful. Why? It's very difficult. I think 3 reasons. One, there are quite a difference between shadow banking are quite a difference in development countries and developing countries. Shadow banking is less complex than the developed countries. So in many developing countries, the government lacks the driving force or measure to contain the shadow banking. The second reason, I think, the wide scale and the non-transparency, the opaque, bring challenge to the national regulator, let alone the international organization. It's quite difficult to regulate them. Secondly, we lack the technical device. Financial innovation driven by the technology, but the regulator have less force and device of the technology. So it is not easy to coordination of the regulation of shadow banking in different countries at global level. But we can step by step. First, I think we can cooperation in the regional cooperation. And we can take use of the technology. Because I'm not the expert of the civil procedure law and international law. So I think I shouldn't waste us time, and we leave more time for our outstanding and excellence experts. Thank you. Thank you all.
Thank you, Professor. And now we will continue with our discussion about these conventions and lead into the next, I hesitate to say, but the next generation of convention, which of course is the latest in this area, the access to justice.
What is the PowerPoint? This one's this computer. I'm just looking for the mouse. Yeah, thanks. I'll be worrying if it is gone. Oh, here you are. Thank you. This one. Yeah, I nearly opened the So both screens are showing.
Okay.
Your PowerPoint. If you just click one of these buttons, it will
Tick,
change.
tack.
Yeah.
Thank you.
Okay for you.
Thank you. Okay, thank you very much. And before starting with my presentation, I would like to let me make two brief disclaimer. The first one is that I wouldn't have to be here. If you look at the printed program, you will see instead Professor Eugenio Hernández Breton from Venezuela, who has had the very bad idea to get sick some days before this conference. And as a consequence, the organizers decided to make me the postpoint gift to sit in a second panel, which I of course accepted. And that is the reason to take the floor for a second time, and I apologize for that. The second disclaimer is that I will break a little bit the common topic on Hague Conventions in matter of civil procedure, and that is because when I received some days ago the notice in a very short time from the organizers that I will be also in this panel, I took contact with Professor Hernández Breton in order to know which topic he intended to address here. And he answered me, well, my idea is to talk about the Azadeh principles on transnational access to justice. So given the fact that I am also a drafter of these principles, well, at least it's not that bad, my new commitment, because I can talk about something I know. I will be very, very brief. It really is not a presentation of the principles, it's just, I can say, a notice of the existence of this presentation. We intend to really present these principles by means of several leading law journals in different parts of the world very soon. So what is this? Our ideas is not, we are not talking about something new. I repeat what I was saying yesterday, but just something which exists in many international instruments and many modern constitutions, but it is not put clearly in these languages. And so our idea is just translate what exists in international human rights conventions and international case law on human rights in black letter rules. That has been accomplished by professional association. It's the American Association of Private International Law. This is an association gathering more than 300 scholars and other specialists in private international law from all countries of the Americas. When I say from all, I'm talking about not only Latin American countries, but also United States and Canada. And we have some very active scholars, for example, from the United States, like Simeon Simeonides, Ralph Michaels, or George Berman. And we meet every year in different parts of Latin America, and we try to have a very open spirit, even if we are, as a definition, a regional organization. Our mantra is to be open and to construct bridges with other regions of the world, and several of the people present here has been participating in our meetings in order to interact with us, and we are really very hungry to feedback from all other regions of the world. And this work of the principles was made in around 4 years of work, 3.5 years, and the principles were ultimately adopted by the Assembly of the Association at the end of 2016 in the meeting of Buenos Aires. 2 or 3 words about the principles. The first one is, you can see there a part of an excerpt of the preamble, and in the first paragraph you have in the screen, you can see some of the very principles of this instrument. The first one is that the principles represent minimum standards. So the idea is not to block the possibilities to anyone to give more room for the access to justice. That what is written in the principles is the idea to put really the minimum requirement for access to justice. Maybe for someone is already very high, but the idea is not that. The second principle embraced in this first paragraph you have looking at is the idea of no discrimination. This idea is based on the assumption that if we are talking about fundamental right, the exercise of that right cannot be submitted to a requirements of nationality or residence. Otherwise, they are not fundamental. So if we accept that they are fundamental, are enjoyable for anyone, with irrespectively of his or her nationality and part of the world in which he or her has decided, he or she has decided to live. And third, we are not inventing principles, as I already mentioned, but we are trying to put in private international law language what is already present in many international law instruments. The second paragraph I put in this slide deals with a more technical issue. And this paragraph answers a problem that we find in many occasions when we analyze all the materials in order to develop these principles. We find that in any local jurisdiction, the problems are more or less the same, and the problems pervasively are the same, and the same situations happen one time and other time and repeatedly in all jurisdictions. And the notion here is to try to persuade, try to suggest to local deciders that they are really dealing with international issues, even if when they apply domestic laws and when they are taking into account primarily local case law, they are dealing with international cases and they are contributing to international development of private international law, even if they don't know that. The purpose of this is, as you can find with different wording, but you can find in several instruments of soft law, of international soft law. So the idea is to collaborate on the basis of a pluralistic conception of the legal order, collaborate with the application of current legal orders, but also to try to inspire new rules and also new interpretations or modern interpretations of existing rules. And this conception has been particularly developed regarding some set of principles, and namely is the case of the UNIDROIT principles on international commercial contracts by several Latin American jurisdictions. Maybe Latin America is the part of the world in which this openness vis-à-vis soft law instrument is the most visible. And there are many decisions in Brazilian courts, Paraguayan courts, Colombian courts, Argentinian courts dealing with this. We have not that psychological problems that, for example, courts in the European Union have. I don't say that it's better. This is just we don't have. I have other problems. Some words on access to justice. So why we do that? We say, well, why do that? Well, one reason is that was mentioned yesterday by Jürgen Basedow when he pointed out that, well, to do something in this topic, he mentioned in particular jurisdiction, but in general, on these topics, try to make hard law is quite difficult. And that is, we see this situation in many occasions. And we saw that in the inter-American context with some instruments accomplished by the Organization of American States. And so we try to collaborate with international organizations and with local courts and with the actors of the international activities in order to give some options when they deal with international procedural issues. And the problem here, or the human reason behind this this project, is also something related yesterday by Professor Bacedo, which is that there are a part of the actors in international exchange who don't need any help of international organizations, don't need any help for association of professors, maybe from anybody, because they are strong enough in order to provide for very sophisticated services and to pay for that. That is not the case of many international actors. So the current state of globalization makes international activities available for everyone. The problem is that not all of those actors have the possibility to really deal with that, the governance of that international activity. So I think that was the human base on this. You can see some quoting, but this may be not very interesting at this stage. What is clear is that what exists in international conventions and in regional conventions is globally accepted as such, as in particular when we come to the right to access to justice and effective right to access to justice. I draw your attention to the first paragraph here in this slide. It is a decision. There are several decisions repeating the same afterward, but in the first decision here in 2006, the famous judge Antonio Cansado Trindade from Brazil, who was the president of the Inter-American Court of Human Rights, underlined that the Article 6 in the Universal Declaration of Human Rights actually is the contribution of Latin American states to this declaration. And if you look at the current practice in the I'm sorry, Article 8 of the Universal Declaration of Human Rights. In the European context, I am not talking about European Union, but the European Council, and that is to say the framework of the European system of human rights, the Article 6 containing the right to effective access to justice has been invoked and applied more than 28,000 times. It's by far the most interpreted provision in the European Convention of Human Rights. It's the same for the Inter-American Court of Human Rights. And what is important to stress in the case of Inter-American Court of Human Rights is that, on the one hand, the notion of access to justice given by the Inter-American Court of Human Rights is taken lato sensu, so it is a very broad comprehension of what the fundamental right of access to justice include. And on the other hand, this right is considered as a part of the material content of jus cogens. So it's not a matter just of an indication or some cultural datum for local courts. Is compulsory when we come to the Article 6 of the Inter-American Court of Human Rights. And just to finish, let me mention some concrete principles, some concrete elements of the Asade principles, called also transjus, or transjus in Spanish. Just three elements, and I will finish here. On general principles, one of the most important general principles, in my opinion, is the idea of that states have the duty to cooperate, or duty of cooperating with other states. The idea here is that there is not just a matter of comitatus gentium. It's not just a matter of a possibility of a convenience, based on convenience or based on, well, we are good enough in order to collaborate with you. No, it's a duty. So that is not only a matter which is present in some decision of the Inter-American Court of Human Rights, more or less implicitly, but for example, in the new Civil and Commercial Code of Argentina, where it develops a complex system of private international law, it's incorporated as such. So in Argentina, this duty is applicable without any restriction of nationality or residence, is already a compulsory duty for Argentinian courts, and the Supreme Court of Argentina has applied this very consistently. Second, on jurisdiction, the idea is, of course, the first idea is jurisdiction must be based on a substantial connection. The corollary of that it is a general condemnation of exorbitant grounds of jurisdiction. There is the inclusion of forum necessitatis, which is deemed to be exceptional, but especially applicable in cases related to environmental damages resulting from individual employment or consumer matters, and in cases of human rights violations. There is a general admission of the forum non-convenience subjected to some requirements, and also there is a general acceptation, of course, of lis pendens. And finally, on recognition, and I put here the two principles in this chapter because I think it's interesting in the context of this Hague project. The first one is the idea I expressed yesterday, according to which the fundamental right to access to justice, in order to be effective, must include the right to the recognition and enforcement. And the second one is the, in principle, prohibition of reciprocity. There are, I think, the two main principles in this chapter about recognition. So I've stopped here. I'm very sorry to having taken the floor for the second time. Thank you.
Actually, Professor, if I could keep you there, I have a question, but first I wanted to say, instead of apologizing, thank you very much for stepping in at the last moment. We all appreciate having you here with your expertise. I had a question about the duty to cooperate, and while it has been adopted by several courts, as you mentioned, and has been cited, as someone who is in this business on the government-to-government side, is there any discussion of perhaps more than a soft instrument? Because if, for example, I am aware of instances where countries argue over what their obligations are under other conventions, for example, the Vienna Consular Convention, where the assertion can be made, you have a duty to cooperate. The response can be, rather undiplomatically, make me. So my question is there any discussion of coming up with something, a more enforceable instrument, either in the Latin American context or where it seems to be working well as is, or otherwise?
If I understand well, the question is possible developments of the principles. Well, I think that is based on very informal discussions, but I think that first of all, the Inter-American Juridical Committee will embrace this principles. So we endorse these principles. That don't mean to make doesn't mean to make this hard law, because it is just soft law, but with the seal of an international organization. It's something more than we have right now. And I'm looking to a member of the Inter-American Juridical Committee in order to put some pressure on him. And but I imagine that it's possible, but it's not really the goal. But I imagine that it's possible to try to put this in the agenda of the Organization of American States. But I think it's not really the goal, and maybe the idea to put this in the agenda of an international organization, trying to convert this in a hard law instrument or semi-hard law instrument, maybe will have as a result that the good things of this instrument, if there are some good things in this instrument, maybe will be lost, because having myself been involved in the negotiation for international instruments for almost 20 years, I know that the principle of reality is really very hard in negotiations, and more of the things that we put here as a base of a work made by specialists, scholars, etc., risk to be lost in a state-to-state negotiation. We are totally aware of that.
Thank you again. We still have a few minutes that I wanted to open up to discussion, since this is the point of this is Davos style, which I finally, it was explained to me, Christoph, the other day, what Davos style meant, and I said, well, this is perfect for me because I'm capable of going off unscripted and without notes for days. So in any event, I would like to open it up to questions for Professor Fernández Arroyo or any of the other panelists on any of the matters that we discussed this afternoon. Yes, Professor.
The cooperation model of various Hague Conventions is built on a cross-border contact between central authorities. It does not deal with the layers below the central authorities. That is left to the single contracting states. That makes sense. But from the viewpoint of the individual who needs the services of this whole system, these lower layers are, of course, of the utmost importance. Now, I hear that in the US, for this one convention, there are a bit more than 100 central authorities, whereas in Australia, more than 1,000. Are there any guidelines or so of the Hague Convention which help to bring the system of the central authorities closer to the individual citizen? Say, a maximum distance, or so many people per, so many authorities per 100,000 inhabitants, or something like that. Would it be possible to establish guidelines on that issue?
Thank you. It actually, the number of authorities does derive from bringing the service closer to the individual rather than the opposite. In the United States, it is based on, excuse me, who has competency for the document. So, for example, a document that is issued by a state, such as a birth certificate or a death certificate or a marriage license, can be authenticated by the Secretary of State of that state. You can't take the same document to another state and have it authenticated. But it puts that competency in one authority that has the capacity to maintain an updated list and of who are the public officials and samples of their seals and signatures. So rather than rather than moving it farther from the citizen, it's actually moving it closer. Because if you had one centralized authority, the United States is a country of nearly 350 million people, and we have millions and millions of public seals and signatures. And to maintain that all in one central locus would just be unworkable. Yeah.
So if you are a citizen of Rhode Island, that's a wonderful situation. A small state, you have less than 50 miles to the central authority. But if you're a citizen of Texas or Alaska, that's difficult. What I mean is access to justice is also an issue of distance. And if you are in an electronic society of the future, this may no longer be a problem. But at present, it still is.
Well, I can say, at least in the United States, all of the states offer mail service. So all you have to do, it's a 2 to 3 day turnaround. It's not that you would have to go, if you lived in northern Alaska, that you would have to go all the way to Juneau to take care of it. You could mail it in. But as you say, in the electronic future, that may not be an issue. And we have had more jurisdictions in the United States experiment with the electronic register than have with the actual electronic apostille, largely because there hasn't been as much demand. But when the demand is there, I'm sure that we will be stepping to the plate, just as other countries have already. And the competent and central authorities under the various conventions are always looking for ways to maximize efficiencies, and because it's not in their interest to have a process that let's say that upsets someone who might be wanting to write to their congressman. So, for example, under the Service Convention in the United States, previously, 15 years ago, the central authority would receive all requests and give them to law enforcement officials who would go out and provide service of process. And it was a very low priority for the U.S. Marshals Service, so it could take months. And the Justice Department recognized this, and they were able to contract it out to a private process serving company. So now they imposed a deadline that says 30 days is the maximum number of days you can have for service. So it's something that we're aware of, and I know other countries have also experimented in any way that they can reduce the time and the inconvenience, because after all, that's the whole purpose of all of these conventions, is to make things easier.
Now, the practical reality, of course, is, it's nice to talk about notions of access to justice, etc., but as far as the Apostille Convention is concerned, the practical reality is that members of the public don't often have to have recourse to sending their documents abroad. It tends to be more, in relation to certainly in Australia's case, it tends to be more in relation to international trade and commerce. And the important thing as far as the competent authorities are concerned is that access is reasonable, having regard to the circumstances. The fact that somebody wants something done now, and commonly they want it done yesterday, because it needs to be in France or Germany or wherever it is the day before yesterday. My bootmaker has got a sign up in his office that says, "Your lack of planning is not my emergency." And that's the way it is. People have an unreal expectation as to what can and should be done for them. The truth of the matter is, in most countries, the competent authorities take their role very seriously and try and provide adequate and proper service within reasonable time limits. What I was saying before, and perhaps didn't explain it properly, is that there are a number of countries that have gone overboard. And frankly, and the example I used was South Africa. What does South Africa need with nearly 1,500 competent authorities. It really doesn't. But you take the United States, which is the world's third most populous country. If you've got a competent authority in each state and territory of the United States, as well as certain of its courts, it provides a facility and a service to cover the vast majority of people most times under most circumstances, and that's what we're looking for.
Yes, can I ask a question? Just now we talked about the Apostille Convention and the Taking of Evidence Convention. Can I ask, may the Hague Conference do something beyond the Apostille Convention and the Taking of Evidence Convention? In international litigation, in civil and commercial matters, various evidences could be involved. By the Apostille Convention, the public foreign documents can be used in another country. By the Taking of Evidence Convention, we could also resolve some of the problems regarding evidences produced in foreign countries. But beyond that, actually there are also many evidences that couldn't be covered by the Apostille Convention, either couldn't be covered by the Taking of Evidence Convention. I have been wondering if possible for the Hague Conference to take some measure to, say, to make a model law or to even a convention for unifying the adoption and acquiring of evidence produced in foreign countries. Thank you.
Well, I think the notion of combining those areas would be a very, very difficult negotiation, if possible at all, because you're dealing with substantive rules of evidence involved in each of the member states, and they are extremely variable, which one of the beauties of the success of these conventions is that they can be adapted cross borders, regardless of whether it's a common law jurisdiction or a civil law jurisdiction. The more the conventions seek to get into the actual process itself, I think it makes the likelihood of success much less, because you'll have fewer countries that will be willing to participate in having what's perceived as an external organization and or instrument getting into their substantive rules. So I don't know that that's possible, but I do know that in my 15 years of working with the Hague Conference, they're always willing to entertain new ideas.
Yeah, thank you, and thank you for the presentations. This is a question for Professor Fernández Arroyo, because I'm interested in your conclusion about reciprocity. It is true that reciprocity has a very bad reputation nowadays, and it is true that it is unfair because we are punishing a private person for something that the state is doing. It's like, I think Germans say, it's punishing the donkey when you punish the donkey's owner. However, it is true that reciprocity may fulfill, at least in theory, an important function, and is to force other states to cooperate with you. And I was wondering whether you consider other mechanisms, if you do away with reciprocity, you consider other mechanisms to force other states to cooperate with you, because the principles are very cooperative friendly, that's true, but I think that it is unfair to open your state to cooperate with other states if other states don't want to cooperate with you. So I'm only, I would be interested if you discuss this issue and whether you figure out any other mechanism to force other states to cooperate with you.
Oh, thank you. I think it's not for the principles to play this role of force countries to be more respectful with cooperation or recognition and enforcement of foreign decisions. But if you look at the principle as I put in the slide, the idea is there is a presumption. It's not a hard rule and really mechanic rule of reciprocity is totally avoided. Is the requirement of reciprocity is presumed to be against access to justice. So that, I think, can allow for very particular situations to take into account some special feature of those situations. But in order to educate the states, maybe it's just the very spirit of the principles that can play that role. But we have not a rule in that sense. I can also mention that in many legal systems, including the majority of Latin American legal systems, reciprocity is already abolished. So there is not a requirement of reciprocity. And when reciprocity exists, in talking about duty of cooperation, of duty of recognition and enforcement of foreign decisions, actually it's not applied because it's not required by courts a real proof of the not existence. Even I can say it's quite difficult to prove that non-existence of reciprocity. So I think I am quite comfortable with the principles as they are. So I know that could not solve the problem of reciprocity. There are, in the same way, we can say, for example, there is a duty to cooperate. And what happens if the cooperation is required by a court of a country in which the due process is not respected? For that reason, there are a series of caveats or series of exceptions in our principles trying to give escape for that particular situation. But the important is to give the message of the general rule. Of course, there will be always exceptions for those general rules.
Okay, thank you, Professor. I believe, Peter, you had one more comment you wanted to make?
I just want to say that I've always been very, very uncomfortable with the notion of forcing people to do stuff. One of the interesting things about the Apostille Convention, it's based on what can only be described as enlightened self-interest. And it's not a convention that deals with matters of high theory. It's a very practical convention. I mean, for instance, we've got in Australia something to the order of 700,000 foreign students have come to our country. Now, each one of them, when coming to Australia to enter into an educational institution, have to typically bring 3 or 4 documents at least from their country of origin, certifying a raft of matters, not the least of which is their nationality and their educational qualifications and so on. I have to say to you that in the case of those students from Apostille countries, it's a lot easier to deal with them, or for the Australian government and for the institutions to deal with them than to deal with students from those countries that are not subject to the convention. And this Apostille Convention works, and it works because people need it and because people can use it on a day-to-day basis. And that's one of the great things about this convention and various others of the Hague Convention.
Okay, thank you, Peter. I'm looking at the clock, and I do not, again, want to be the person who stands between you all and the... Oh, excuse me. We have one more question? A comment.
Thank you very much. And this is just to come back to the previous question, and first of all to endorse Bill's answer to it. But this is the type of situation that always prompts me to say that certainly the Service Convention has actually the wrong name. It's not about service. right? It's about the transmission of requests for service, but then the scope of application of the convention actually stops at that question, and the actual service is left to national law. Same for the evidence convention. It's about facilitating access to evidence, as it were, but the actual taking of evidence is left to national law. And I think that is part of the success of these conventions as well, as Bill rightly pointed out, because we do not interfere with domestic procedural law. What we do, however, in terms of going a step further, is cooperating with other organizations and institutions that do exactly that. So, for example, in the field of service or execution of proper, actual execution, enforcement of judgments, we work closely together with the Union Internationale des Huissiers de Justice, the international organization of judicial bailiffs, who has the actual expertise in these fields on how to effectively serve process, on how to effectively enforce a judgment at the very end of the day. They have developed what I consider to be a highly interesting global code on the execution of judgments, which we encouraged them to bring to Unidroit, because that is the more appropriate organization to deal with these harmonized rules than the Hague Conference. But our mandate currently, as limited to proper private international law, would probably prevent us from doing further work in this field.
Thank you, Christoph. And this serves as also a reminder that tomorrow, of course, there will be a breakout session on international legal cooperation, civil procedure. So, other questions, I'm sure that that would be a great forum to raise these issues as well. So, again, I don't want to stand in the way of people and coffee, but I do want to thank all of the speakers for being here and providing us a very engaging hour and a half plus. And please, unless you have anything, I would say it's time for coffee. Thank you.